But I'm going to close it out with our closer, Ryan Brannon. The plaintiff's lawyers are planning to bring these types of claims. I say that because I had a plaintiff lawyer who will remain unnamed send me an email letting me know that he is taping his commercial to run in the near future for COVID-19 work injury claims. So they're coming. We don't know how many are coming, but you can expect them to come at some point in the near future. If you're not already having claims, at some point, claims and civil lawsuits. So with that said, let me get to Ryan Brannon. Ryan is the founder and principal of the Brannon firm. He is the former department head chair. I know I butchered the title, but of the Department of Workers' Compensation in Texas. He is operating a results-oriented government affairs firm, and he also serves as counsel to the law firm of Glass, Phillips, and Murray. He's got a ton of stuff to talk to us about, so I'm just going to stop and let him start. And the question I'll pose to him is, what efforts are underway at the Texas Governor's Office and at the Texas State Legislature to get Texas employers back to business and to protect them from potentially frivolous civil lawsuits alleging COVID-19 exposure?
Well, that is broad, and I appreciate that because everything is changing on a daily basis, it seems. We're moving at lightning speed all over the place, actually. And I'll try and break it down as best I can in the next few minutes. And I want to start by going all the way back to the 2017 legislative session when the Texas legislature passed a widespread, if you will, telemedicine bill that widely changed the restrictions and geographical uses and abilities of where you can and when you can use telemedicine. And back then I was the commissioner of workers' comp in Texas and saw that while there was a lot of people with opinions about whether or not telemedicine was a good idea or not, it didn't matter to me. The fact is telemedicine was here, and it was whether or not we were going to do something about it to innovate the way we approached. And so I asked our team to put together a telemedicine rule, and they did not want to do it. They were still of the mindset that this is still up to them whether or not we do it, and actually brought in Corvell and another company to demonstrate to our staff how telemedicine would work in the workers' comp system, and they finally got it. So thank you, Corvell, Karen, and your team for coming over and doing that. We passed the rule that basically just made a playing field, if you will, for telemedicine to be able to operate in Texas, and gave a lot of leeway to companies to figure out how they wanted to go about doing it. And I mention all of that, obviously, as telemedicine is a very important topic right now. It's been mentioned by several of the people on this panel. But telemedicine was one of the first regulatory, loosening of the regulations that we saw coming out of the Division of Workers' Comp and the Department of Insurance. And when everything was first kind of happening around the COVID-19 government reaction, the two main things that we saw across the board were loosening of regulations, everything from trucking to occupational licensing to telemedicine, everything in between. And we also saw a slew of executive orders from the governor. I think we saw 6 in the first 10 days. So we knew right out of the gate that this was going to be a big disruptor. If you recall, I actually penned a letter to our members saying that there are 3 things you need to be doing. One, trying to figure out, if there's any regulations or an executive order that will help you continue operating effectively. 2 was to go ahead and start trying to figure out a way to make your company essential. Back then, in particular, there was a big distinction between essential and non-essential businesses, and those were changing a lot. One executive order would say that the industry was essential, and then 2 days later, it wasn't anymore. So we were watching those very closely. And the third thing was just making sure that you, as an employer, figured out a way to move forward through the environment as it's ever changing, and look at ways to innovate the way you do business. And I think for the most part, people are doing all of those things. For ARAWC in particular, we put together a task force of folks, industry, legal, obviously advocacy to figure out what it was that we could request from the governor in order to protect our members. And overwhelmingly, we found that the employers that were members of ARAWC were concerned about liability. So I was glad to see we had a couple experts here on this panel to discuss it. We ended up coming together and deciding to have two specific recommendations on liability, both the negligence and premises liability, and those were to change the standard of care to gross negligence, and also to require an expert opinion report if you're going to file a lawsuit. One of the initial things after we decided that those were going to be the things that we asked from the governor was reach out to other employer associations to let them know that we had seen it. You know, sometimes you forget that as risk managers, we see the risk a lot earlier than other areas of these organizations. And so when we talk to the restaurants and the Hotel and Lodging Association and the retailers and the Texans for Lawsuit Reform and the Texas Association of Business, and, all of them were like, yeah, we're generally aware that this is a problem, but none of us have gotten this specific or granular yet. About that time, the governor announced a strike force to open Texas. That was 10 days or 11 days ago now, with about 30 members of his advisory committee, which were primarily employers and health experts, to figure out a plan forward. And so we began launching a letter that we wrote into the strike force, sending it to the different members that we knew, sending it to the governor's office, anybody that we thought could be helpful. I received confirmation Friday afternoon that our proposals were discussed with the CEO and COO of the strike force and the governor. Ultimately, the governor came out yesterday with GA 18, which is one of his most recent executive orders, but it's the executive order for the plan to open, which just lays out, 3 phases. The first phase going to the 18th of May, 25%, 50%, 75%. Most of you probably are aware of that at this point. And there was no mention of liability protections at all, which disappointed many. But we had a feeling that with that first executive order, first round of the announcements, that at a time when he's trying to get employees back to work, it was going to be a really big ask to then go ahead and tell those folks that we've got to protect the employers. Now, just because that didn't happen yesterday doesn't mean it won't happen at all. In fact, I'm pretty sure it will, because we're hearing from a lot of smaller and mid-sized businesses, like in the retail and restaurant space, that opening up at 25% is not enough to even remotely guarantee that they can break even, let alone turn a profit. And so a lot of them are going to sit on the sideline and wait as a result of that, which means that the economic recovery will likely be slower than anticipated based on the first 2 weeks and try and get people back together. So as we try to ramp industry back up here in Austin, they're going to be looking for more solutions on how to do that. And obviously employer protections on liability is a huge way forward. And we're already seeing that those changes. President Trump has said that this is an issue for him, and that they're looking at how the best way to do it is. In fact, today, he used the Defense Protection Act. I don't know if he's signed the order yet or not, but he announced that he was going to use the Defense Protection Act to keep the meat processing plants moving forward, even in the face of the Tyson letter in the New York Times yesterday, and the plants wanting to shut down, potentially losing up to 80% of our meat supply in America. President said absolutely not. But then he had to acknowledge that the only way to do that was to sign an executive order regarding liability for these plants. So that's the first step forward. We'll see what the executive order actually looks like. But given the fact that all the states are taking their orders from the president right now, president's recommended 3-phase guideline is exactly what Texas and most other states are doing, on different dates and times, but the process is the same. And so if the president starts to move this direction, it's going to give the governor a lot of cover to be able to sign something like that rather than sticking his neck out in a time of uncertainty. And so that's a very positive development. The fact that Mitch McConnell has already told the Senate that they're coming back on May 4th and also believes this is a big issue, gives a lot of cover as well. And at the state level, we don't need the federal government to actually pass a bill in order to act. We just need some cover. And so we're starting to get that, and very positive development. We'll see where it goes from here, but I think it's looking like we might get some of those protections that we're hoping for.
Ryan, other than the governor of Texas addressing it through executive order, what other type of potential solutions may be in our future to address liability exposure?
It's a good question. So if he doesn't do it by executive order, then you'll need legislative action. And quite honestly, you'll probably need legislative action when the state is no longer declared a disaster area, because the governor's powers are far broader in a disaster time than they are when it's not. And so a lot of these executive orders will potentially have to be rescinded at that time. So the two ways to get legislative action are either through the regular session, which would begin in January of next year, or the governor can call an emergency session, or special session as we call it, and bring them back earlier than that. I've already spoken to other groups such as the Texans for Lawsuit Reform, and we kind of feel like this would be a good shot if the governor does make that move to get added to the call and get a bill through. And one of the reasons why the special session's on the table at the moment is because no one has any clue right now what's going to happen in the November elections. Texas was already on the verge of having the Texas House go from a Republican majority to a Democrat majority. And if the state feels that the Republicans have bungled the response to this, you could see those elections turn blue, and good luck getting tort protections through a Democrat-run House. So these are all things that we're considering right now, and we're trying to prepare for every different permutation that this could take, and make sure that we're positioned to get what we want.
Well, thank you, Ryan, very much.